All right, I think we're ready. So I'm going to go ahead and get us started. My name is Amy Wildermuth, and I am the Dean here at the University of Pittsburgh School of Law. It is our great pleasure to be able to present this 2020 Constitution Day event entitled The Constitution of Enslavement and the Constitution of Freedom, a conversation about Professor William Carter's scholarship and the contemporary relevance of the 13th Amendment. Now, it's my honor to get to introduce all of our terrific panelists today. So I'm going to begin with Chip Carter. Most of you know Chip from his 6 years as Dean of the Law School. He's also been a faculty member at Temple and at Case Western. Chip has accomplished so much that I can't spend enough time here today to give him everything that we should say about him. But let me say this. His scholarship has been impactful for years. The kind of work that he has been doing has been transformative in this area of the law. We are so honored and privileged to have you as a member of our faculty, Chip, and I'm so excited to get a chance to talk about these two papers. The most recent one, we should say, that will be published in the Texas Law Review in the upcoming year. We also have joining us as commentators David Harris, who is the Sally Ann Semenko Endowed Chair and Professor of Law here at the University of Pittsburgh. He studies, writes, and teaches about police behavior, law enforcement and race, and politicking and immigration, search and seizure law, and national security issues and the law. He is a leading national authority on racial profiling. He's written numerous books, numerous articles, but the thing that I always like to say about David is that he remains deeply invested in our community, including the university community, where he's serving as the chair of a very big public safety task force here, and he is currently a member of the mayor's task force on police reform. Finally, we have Jalila Jefferson-Bullock here with us as well. She joins us from Duquesne University, where she is an associate professor of law. Her teaching experience includes courses in constitutional law, criminal law, and criminal procedure. Her research interests include constitutional law, criminal procedure, federal sentencing, legislation, and civil rights. Her current work focuses on sentencing law and policy reform and the need to de-emphasize traditional incarceration. I am so delighted that we have you here today, Jalila. So let me also thank Associate Dean for Research and Faculty Development, Debbie Brake, who is our organizer for this terrific event. Now many terrific Constitution Days under your belt, Debbie. Thank you so much. I have to say, every time you wow us again. So thank you so much for your efforts, and I'm going to turn it over to you as our moderator for today.
Thank you so much, Dean Wildermuth, and thank you to everyone for joining us on the 2020 Constitution Day Pitt Law program. At this particular moment of reckoning with racial injustice now taking place in America, we wanted this year's Constitution Day theme to focus on the Constitution's reckoning with racial injustice. The core of racial injustice in America and at its founding was slavery. The 13th Amendment, ratified 155 years ago, marks the Constitution's quintessential reckoning with that most unjust of institutions. Knowing that we had and I'm going to say the, leading national scholar of the 13th Amendment on our faculty, Professor William Carter, we had our focus and our featured speaker. In putting together the program, we also knew that due to the pandemic, we would be doing this Constitution Day remotely. So instead of our typical format of one long lecture, we wanted to frame this as more of a discussion. And being a law school, a scholarly discussion, and we wanted to build in opportunities for interaction and dialogue. So we decided to focus on two of Professor Carter's scholarly articles, which were made available to registrants in advance of this program. But don't worry, if you didn't have time to read both of them, we will not be calling on anyone. We are also incredibly fortunate that the Pitt Law community has other deep wells of expertise to draw upon in the realm of the Constitution and racial injustice. And I am deeply grateful to Professors David Harris and Jalila Jefferson-Bullock for generously sharing their expertise and joining this discussion. So our format is as follows. Professor Carter will begin with some opening remarks discussing his 13th Amendment scholarship. Those remarks will be followed by commentary, first from Professor Harris and then from Professor Jefferson-Bullock. After those comments, we will come back to Professor Carter for his reactions. And then I, as moderator, will take questions from the Q&A function over Zoom. So you can write your questions in the Q&A at any time for the host and moderator to see. We will conclude the program at 1:30. Professor Carter, I turn it over to you.
Thank you very much. And thanks to Dean Wildermuth for the kind introduction. You're far too kind. Thanks in particular to Associate Dean Brake for all of the work that she put into this program. Essentially, I just have to run my mouth for 20 minutes, but she did, along with our staff, all of the work in actually making it happen. So thank you. And then I also just wanted to thank both Professor Harris and Professor Jefferson-Bullock for taking the time to do this. Your expertise is going to be quite valuable in the conversation. David, you know that you've been a scholarly mentor and role model to me on these issues, so I particularly appreciate and look forward to your insights. And Jalila, although we haven't gotten to know each other personally, I've had occasion to read quite a bit of your scholarship and have been deeply, deeply impressed and engaged with it. So I really look forward to your contributions in this conversation as well. So what I plan to do is to spend no more than 20 minutes at the absolute most, kind of laying a frame in terms of the background for the two articles under discussion today, and then at least going over the surface of the articles themselves, and then I'll look forward to my colleagues' comments and thoughts, and we can engage in a discussion about them. I did think it was important, though, to provide some background regarding slavery itself, because, of course, that provides the background for the work that I've done regarding the 13th Amendment and the post-Civil War Constitution. So if you will bear with me for a moment, I will see if my technical facility is up to doing a screen share. I just have 2 or 3 quick overview slides that I wanted to share by way of making some points regarding the nature of slavery in the United States. So please bear with me. As you all know, it's important to understand the history of our system of race-based enslavement in order to understand the Constitution that allowed it, as well as the post-Civil War Constitution that outlawed slavery in the quest for a more egalitarian political society in the United States. It is clear from my research that the issue of slavery and what the 13th Amendment's framers called the slave power had come to dominate the nation. The beginnings of the transatlantic slave trade have been discussed in great detail in other scholarly works, and so I will not go through that in any detail, but a few contextual points are important. First, approximately 12 million Africans were enslaved and shipped across the Middle Passage to the Americas. At least 2 million of them died on the voyage itself, and approximately another 1 to 2 million died during the overland trek in the United States from the coast to the interior. One fact about the slave trade that's easy for those of us in the United States to miss is that, in fact, most of the slaves shipped across the Atlantic from Africa were sent to places other than North America, that is to say the Caribbean and Latin American destinations such as Brazil. Fewer than 10% of Africans who were enslaved and shipped across the Atlantic ended up in North America. And so there's some interesting comparative law scholarship that I don't have time to get into today about how the dynamics of slavery played out quite differently depending upon the density of the slave population throughout the Americas. It is also worth noting that prior to the beginning of the formal system of African slavery in the British North American colonies, that millions of Native American and indigenous peoples, at least 3 million, were subjected to enslavement prior to the system of African slavery becoming embedded. The system of American slavery had one of its core aspects, an evolving and evolutionary development of the law, as was needed to maintain the system of human bondage. So initially, the 20 and odd Africans who arrived in 1690 Virginia were not legally yet operating on the same system of enslavement that eventually developed in the United States. As slavery evolved in response to changing social and economic needs and increasing numbers of African slaves, it evolved in the slave states into a system of perpetual, inheritable, and race-based subjugation, under which slaves were treated as saleable property, and all Blacks, even free Blacks, were subject to a wide degree of legal restrictions and social stigma, as were the enslaved. The overlapping and interlocking legal aspects of human bondage were not limited to the property and labor relationship of slavery itself. Rather, the slave power developed an all-encompassing series of laws, customs, and norms, as well as constitutional provisions that created a race-based caste hierarchy in service of and deriving from slavery. The Constitution itself, it is much debated whether our original Constitution was pro-slavery or anti-slavery. For purposes of my talk today, that's a bit beyond the scope of what I wanted to mention. But I think at minimum, it's fair to say that the original Constitution permitted slavery and embedded provisions in the Constitution that facilitated it. And I wanted to just take a moment to lay out a few, although I won't discuss them in any great detail. Most of you would be familiar with the 3/5 clause, which provided that enslaved persons would be counted as 3/5 of a person for purposes of apportionment. The goal of that provision was that, of course, in the slave states, if the slaves were not counted at all in terms of the population, then the southern states would have lesser power in Congress because a greater portion of their population than in the North consisted of non-voting slaves. The slave trade clause in the Constitution itself, Article 1, Section 9, Clause 1, expressly forbade Congress from outlawing the international slave trade prior to the year 1808. This was one of many compromises in the original Constitution where the founders sought to buy time to try to resolve the issue of slavery through internal political development rather than outlawing it immediately. And indeed, the southern slave states insisted that this clause be part of the Constitution. The Fugitive Slave Clause, which most of you would be familiar with, provided that in a nation comprised of both slave states and free states, a slave escaping or being taken to a free state would not thereby acquire the status of freedom. Rather, such state would be bound and required to deliver up the person upon a demand by their putative owner. And the Fifth Amendment's Due Process Clause, at least as interpreted by the judiciary, put a higher premium on the property right in human beings than it did on the liberty interests of enslaved human beings themselves. There are a variety of other constitutional provisions that, again, at minimum, represent our founding compromise with slavery, and I won't go through them all. The broader takeaway from this first overview point is this: notwithstanding this series of compromises, as you know, in the words of President Lincoln, the nation ultimately could not exist half slave and half free, as he said in his famous House Divided speech. The constitutional compromise with slavery then was never truly secure, and ultimately failed, leading to a cataclysmic civil war. There were a variety of political and legal conflicts prior to the Civil War, such as the so-called Bleeding Kansas dispute arising out of the Kansas-Nebraska Act in the 1800s, the adoption and the failure of the Missouri Compromise, cases like Dred Scott and Prigg versus Pennsylvania accelerated the growing tensions regarding slavery. And all of those convinced the abolitionist movement, which early on had been somewhat more moderate, that enslavers and their allies were not going to settle for a compromise that left the nation half slave and half free, but rather that the goal of the slave power was to expand slavery throughout the entire United States. As the conflict became increasingly heated regarding the issue of slavery, we know that it, of course, culminated in the Civil War. I won't talk about the war itself in any detail. I'm not a historian, but it is worth making one point because it's relevant to my and the other scholars' understanding of the post-Civil War Constitution. It is almost impossible to truly imagine the scale and profound impact of the Civil War and the fundamental rift that it created, in my view, in our constitutional regime. The Civil War, of course, was a cataclysmic battle fought on US soil in which 600,000 people died at a time when the population of the United States was 10% of what it is today. So if we translated that into contemporary terms, 6 million Americans would die in a war like that on American soil if it were fought today. The war itself touched every corner of the country. The issue of slavery is one in which nearly all persons, whether they were themselves enslaved or slave owners, felt an ideological stake. And the outcome of the war, that is the outlawry of slavery and the adoption of the post-Civil War constitutional amendments, was seen by both the victors and the vanquished as representing a fundamental break with the prior constitutional regime, what I've called, for purposes of this talk, the Constitution of Enslavement. And so the framers of our post-Civil War Constitution truly did think about it and speak about it as amounting to a second American Revolution. That insight then influences the way that I think we should interpret the Constitution as a whole as we try to synthesize the principles and provisions of the original founding with those of the second founding. And I will talk about that in some more detail momentarily. The 13th Amendment was the first post-Civil War constitutional amendment. The amendment, of course, constitutionalized the practical result of the Civil War, that the legalized system of human bondage would no longer be permitted in the United States. But the framers of the 13th Amendment also intended to not only outlaw the system of chattel slavery, but to also empower Congress to address what they called the badges and incidents of slavery. The provisions in our law, and indeed through private action, that either were grounded in slavery, supported it, or were legacies of the system of enslavement even after its formal end. And I want to share just a couple of quotes from the founding debates around the 13th Amendment to give you a sense of what its framers believed that the new Constitution would do. Senator Lyman Trumbull, for example, in the debates leading to the adoption and eventual ratification of the 13th Amendment, said that the amendment would destroy slavery itself, but would also destroy the incidents of slavery. And so all of the race-based laws that existed in service of slavery, those that restrained the movements of both slaves and free blacks, that prohibited his engagement as a full member of civil society in terms of being able to own property or to make enforceable contracts or to have equal rights under law, were all badges of servitude made in the interest of slavery and as a part of slavery. They never would have been adopted were it not for slavery. And Senator Trumbull said, when slavery falls, they fall also. And so in his view, our post-Civil War Constitution had a remedial focus as well as its immediate goal of ending slavery. It was intended to eliminate the legacies that had arisen as part of the slave system. Representative Myers of Pennsylvania spoke similarly. He said that once slavery itself is gone, its laws, prejudices, and consequences should be buried forever. If there are wrongs, now is the time to right them. If there are defects, this is the forum in which to remedy them. He saw his responsibility then as a framer of the post-Civil War Constitution, as remediating the legacies of slavery in addition to abolishing the slave system itself. The 13th Amendment then, in my view and that of other scholars, represented a clear break from the prior constitutional regime. And in addition to enacting new rights, it also, in my view at least, changed some of the fundamental premises of the prior pre-war Constitution. It changed the balance of federalism, did not eliminate it, but it changed the balance of federalism. It changed the balance of power between what was then a pro-slavery Supreme Court and Congress, making clear that under the Reconstruction Amendments, the post-Civil War amendments, that Congress would have primacy in protecting and advancing civil rights. And it advanced a new notion of who was a member of the political community entitled to civil rights. Whereas prior, Blacks generally and enslaved persons specifically were not seen as part of the American polity with a voice in constitutional meaning. Now, they were to be seen as full members of our civil society, whose views on constitutional meaning, as I'll elaborate on in a moment, would count every bit as much as the freeholders and free people who had never been enslaved. So, what do I draw from all of that for purposes of these two articles that are under discussion? The first one is regarding the 13th Amendment and racial profiling, which was written in 2004, I think. And the most recent one, which will be coming out next year, is regarding slavery and free speech. And so what I want to do for the sake of time is to just really go over the top of the theses of those two articles. And then we can dive into further depth based upon the input by Professor Harris and Professor Jefferson-Bullock. So in my racial profiling article, what I was looking for was, is there a legal theory or an approach that might be more effective to addressing the issue of racial profiling than the dominant Fourth Amendment or 14th Amendment judicial approaches? The issue with the 14th Amendment equal protection analysis of racial profiling is that, as those of you who are students and lawyers know, the state action doctrine, much of our constitutional equal protection doctrine only operates where the actor in question is a governmental actor. And many occasions of racial profiling are either carried out by private action or initiated by private actors. And so the bright line state action doctrine presents some problems in that regard. The Fourth Amendment remedy, the door was essentially closed to that in a case called Wren versus the United States. Pretextual traffic stops, the court held, could not be interrogated for racial bias as a matter of Fourth Amendment law. And so I was seeking to see in that early article whether a 13th Amendment approach might provide a better remedy for instances of racial profiling. And I argued that it did. I argued first that we should see racial profiling as a badger incident of slavery. That is to say, the widespread use of race as a proxy for criminality, and the use of that proxy as a trigger for stops, seizures, and surveillance imposes widespread limitations on the freedom of movement of Blacks, but also inflicts a dignitary or stigmatic harm upon Blacks, similar to the lengthy history arising out of slavery of the conflation of Blackness as a signal of danger and as something that required very strict social and governmental control. And so my argument in that article, as those of you who had a chance to read it know, is not that modern day racial profiling is equivalent to slavery. I want to be very clear about that. In none of my 13th Amendment work do I come close to arguing that the very real and very significant racial disparities that people of color and African Americans in particular suffer today are equivalent in any way to a condition of enslavement. They simply are not. And it is revealing to read and understand from slave narratives what slavery was really like for the people who lived through that experience. So I just want to be clear, my argument in this first article is not that modern day racial profiling is enslavement, nor that it is akin to enslavement, nor that it is analogous to enslavement. I think that arguments of that kind do a disservice to people who were enslaved. What I do argue is that, drawing in large part on a Supreme Court case called Jones versus Alfred Mayer, when we understand the rather radical purposes of the 13th Amendment's framers to reshape a system of laws and customs that had fundamentally been grounded in race-based suspicion, and when we see the reproduction of a similar condition today, it would be considered a badge or instant of slavery that Congress is empowered to eliminate as part of its overarching power to eliminate the vestiges of slavery in our civil society. In the more recent article about slavery and freedom of speech, I'm still dealing with the post-Civil War Constitution, but in a very different way than in that first article. So there is a lesser known portion of our constitutional history regarding freedom of speech that this article in part is designed to illuminate. Generally, the story in our law about the First Amendment is that it was ratified in 1791 as part of the Bill of Rights. Shortly thereafter, the Congress that passed the First Amendment also passed the Sedition Act, which made it a crime to criticize the President of the United States, and that very cramped and limited view of the meaning of the First Amendment survived until the 1920s, when Justice Brandeis and Justice Holmes suddenly saw a shaft of revelation from the heavens and revealed to us our true free speech tradition. There is an intervening First Amendment moment, and indeed a First Amendment crisis that is very much overlooked, both in our constitutional history, but also in the Supreme Court's First Amendment cases, which is this: the battle to end slavery was as much a battle over free speech as it was a battle over human bondage. That is to say this: Blacks, enslaved persons, and abolitionists believed that the forces of enslavement could not win a battle on the merits of slavery if fought fairly. And they therefore sought to invoke a robust right to free speech in order to persuade the country to eliminate slavery short of war. Conversely then, slaveholders and their allies very much understood that limiting and controlling the channels and kind of speech regarding slavery that would be deemed legally permissible would give them an advantage in seeking to maintain the system of slavery and human bondage. And so concurrently with arguments about slavery itself as a social evil, we see arguments from abolitionists and Blacks that the value of free speech would be necessary to win that battle over slavery itself. What I contend in the second article then is, if we understand the post-Civil War Constitution as embodying a new constitutional regime, that the values of that post-Civil War Constitution influence the entire Constitution itself. I do not argue that they displace the original intent or original public meaning of the 1787-1791 Constitution, but rather I argue that they should be layered on top of it and synthesized, rather than doing what we generally do now. When we seek to understand the meaning of, for example, the First Amendment free speech clause, if we want to interpret it from an originalist perspective, we ask only what the framers in 1791 thought it meant, or what the general public understood the First Amendment to mean in 1791. I argue in part in this article that if one is going to do an originalist analysis, we need to take into account both constitutional moments and see if we can synthesize and reconcile them. Secondly, and I think the novel contribution that this article makes is in presenting somewhat of a challenge to intentionalism or original public meaning originalism in this regard. I argue that enslaved persons themselves should be seen as constitutional actors who were part of the general public that imbued the First Amendment with meaning. And in doing so, I then examined several dozen slave narratives to try to suss out what enslaved persons themselves thought freedom of speech entailed. What sort of deprivations in that regard did they suffer? What did they believe that the reconstructed Constitution would change? And it is illuminating to see how deeply many enslaved persons thought about the meaning and value of freedom of speech. So I have gone longer than I intended. I'm going to stop there, and I look forward to hearing my colleagues' thoughts on these issues.
Professor Harris?
Good afternoon, everyone, and thank you for the honor of talking to you on this Constitution Day and the special honor of being part of recognizing the scholarship of my friend and colleague, Professor Chip Carter. I'm going to talk mostly in my few minutes with you about the 13th Amendment framework for combating racial profiling. It's a subject that's it's been near and dear to me for some time, and it was a special treat to reread this piece years after I had read it in the first place. And I guess I want to just start with a comment about academic and legal academic writing in general. I think a lot of us who are in the academic world know that a lot of academic writing is just done to be written. I mean, it really has no higher aspiration than that. And if you've read it, you know that that stuff kind of fades. It doesn't have a sustained value. It's the rare piece of academic writing that we're still reading 15 and more years on from the date of its publication, and still shows its real intellectual and practical power. Even 15 years on. But rarer still is a piece that you read that is not just still powerful, but even more relevant than the day it was published. I want you to think about this. Today, this 13th Amendment consideration of racial profiling is actually more important and more relevant than it was in 2004. Why? Because it's only in the last, say, 3 to 4 months since the death by murder of George Floyd that so many Americans have suddenly opened their eyes to the roots of policing in the United States. When I say this, it is not my intention to condemn all police officers, far from it, but to say that American policing has its roots in some very dark places. In the South, the roots are very clearly the slave patrols, which just happens to be the exact subject, a part of the subject that Professor Carter's scholarship addresses, the practice of slavery and its deep roots in society and the Constitution. And this is not confined to the American South where slavery was allowed, but you see policing both before and after the Civil War in the North as well, used as a tool to keep blacks in line, to enforce social mores that were deeply damaging and discriminating, to be part of the sharp tip of the spear to enforce very bad laws. And that's true everywhere from Vicksburg to Pittsburgh. It is everybody's heritage. And so we have our fellow Americans making these connections for the first time, some in the last few months. And that is precisely what this piece does so well. As we begin in this country to see police forces in their full historical context, a piece of scholarship like this simply couldn't be more important. How does Professor Carter make these connections here? How does he situate the practice of racial profiling within what he calls this new post-Civil War Constitution, what others called the Second Founding, or a new birth of freedom in various different phrases. He does two important things here that I think the best scholarship does. First, he leaps beyond what many of the rest did before him. And I count myself as one of those. I think a lot of us saw the deep social costs of racial profiling, the way it degraded, the way that it cramped social life and had great social costs for Black Americans. And he saw it not just as a faulty and unacceptable way to think about crime or law enforcement, or a faulty way to look at social life, or a damaging way to do that, but also the key for him in his work was that it actually connected to something very, very deep. And that was this idea of the congenitally criminal Black man. We see this stereotype today, of course. It is what perpetuates some of these practices even today. But Professor Carter understood and demonstrated that this goes very deep back into the actual reinforcement of the arguments for slavery. The Black man was congenitally criminal and wild, and therefore slavery was a good thing. We had to keep him under control. And of course, that didn't stop with slavery. Once the institution of slavery was abolished, it persisted in the Black codes and in Jim Crow and in all the customs that grew up around that. And of course, the enforcement job around that was the job of police in any formal sense. So he connects the background of slavery and white supremacy to these practices in the modern world of 2004 and, of course, the present day. The other major contribution here is to see this as a way toward a new legal theory that could do things that the current theories were not. As Professor Carter said in his opening remarks, the Fourth Amendment approach to profiling was basically a dead letter. After the Wren case in the mid-1990s, the Supreme Court said, well, basically you can stop anybody for any traffic offense, and that's that. It's probable cause. We're not going to go behind that. And if you have a case, if you can actually show that there is disparate enforcement taking place, we'd love to hear your equal protection claim. So the Fourth Amendment had nothing to say about this after that. And then, of course, the equal protection avenue was a very difficult road, very difficult path to travel, and did not work out. Let's just leave it at that for the sake of time. He gives us, Professor Carter does, an entirely new framework for approaching this, one that actually could yield some results, unlike the other two that had basically been in play. If you look even at the statutes that have been developed and proposed in the Congress of the United States, they're basically 14th Amendment based. And because of that, their reach is limited. And the 13th Amendment approach had then and still has now real promise as another kind of approach here. And it is all down to somebody looking at an existing field and saying, this isn't all that there is. There's more here. You can find it in both the history and in the founding documents in that time of rededication, that second founding, the 13th Amendment, something that others simply had not noticed. It is the mark of the curious and hardworking mind that we are privileged to have among us on the Pitt Law faculty. And it is that idea, that stereotype of the congenitally criminal Black man that persists today, and that we must defeat today if we are to make the kind of progress that we need to make. I'll just make one very quick final point, and that is in the spirit in which Professor Carter offered to us a new avenue for attacking this problem of racial profiling. I offer another one that was also overlooked often, and that is state and local law as a way to attack this. Along with the 13th Amendment approach, it is the kind of avenue that people have long neglected, but that cities and even some states are beginning to take in hand as a way of not just attacking and bringing to heel racial profiling, but so many other pernicious practices. I want to say thank you for including me in this wonderful discussion, and thank you, Professor Carter, for all of your great work. It's been a real pleasure to revisit it.
Thank you so much, Professor Harris. Professor Jefferson-Bullock?
Good afternoon, and I'd like to say thank you again for having me here today. It's been a pleasure to have the chance to read some of Professor Carter's work. I've been a fan of his for quite some time, and so I'm just honored to be here, and I'm honored to serve with also Professor Harris. And so then to Associate Dean Brake and to Dean Wildermuth, thank you so much for having me. I do appreciate the opportunity. I'm going to speak about both pieces just for a few moments in my allotted time. Embedded in one will be a message, a little bit of hope. Embedded in the second will be a message more of kind of doom and gloom. You'll see what I'm talking about as I go through it. So, and I'm going to start with the second founding and the First Amendment. So in that article, Professor Carter, in his own words, contends that evidence from the constitutional moment culminating in the second founding, specifically slave narrative, is an overlooked source of meaning in interpreting the First Amendment. First of all, let me say that I enjoyed reading both of these pieces so much. I had read the older one sometime before, and it was a joy to read it again. What I got though from the article I just cited from, I began to think, reading it, about constitutional interpretation and what does that mean. So I guess what I'm saying is, what struck me most was what does and what should the inclusion of slave narrative in First Amendment speech analysis mean to constitutional interpretation? Specifically, what does this mean for the inclusion of the historically voiceless? And more specifically, what does the inclusion of Black voices mean to First Amendment interpretation and to constitutional interpretation, generally speaking? So in one section of the paper, Professor Carter discusses originalism. He did so today in his presentation. And he offers that originalist intentionalists might reject the premise of his article because intentionalism would only consider the views of the elite white leaders who were involved in crafting the Constitution. He does, however, suggest that other forms of originalism might support his thesis. He points to the original public meaning strand of originalism and the notion of popular constitutionalism as well. So while he gives a slight nod to a non-originalist interpretation, I wondered when I was reading it why he did not spend more time there, and it became clear that he did not because he did not need to. That is because a popular constitutionalism or original public meaning view of originalism supports the inclusion of a wider variety of points of view in interpretation beyond those of the elite white drafters. That puts, in my estimation, a modern and perhaps more liberal twist, if you will, on originalism. In this way, the article, in Professor Carter's words, doesn't only seek to ascertain and illuminate the views of the enslaved and the disenfranchised in order to make visible their role in both securing and defining their own freedom. In addition to doing that, it also opens a path, a wider path, a path that I would suggest is a kind of a breath of fresh air for considering other freedoms in light of what historically legally oppressed and subjugated classes thought at that time. For example, how could such inclusion inform our view of the right to vote, for example, if we consider the voices of African Americans and consider them as part of the real, the true, the actual record, and we consider what denial of that right meant to them, might that reconceptualize our own current view of voting, and might such a view prove helpful in combating modern day attacks on the right to vote. And I think that there are other areas where if we view it that way, if we take his approach, perhaps we can take a different angle at fighting and perhaps be successful at attacking some of these inequalities that exist. So the idea then of attaching history is what became important and what kind of struck to me, not just history in the way that we've been taught it in school, but a broader, robust, really true view of history, which leads me to the second article, a 13th Amendment framework for combating racial profiling, which advocates for the use of the 13th Amendment in combating racial profiling because the 14th and 4th Amendments have admittedly failed us. While both of these articles speak quite richly to this specific moment, this one resonates perhaps most clearly. Professor Carter speaks of the pervasive view that African Americans are predisposed to engage in criminal conduct, which of course is the impetus of racial profiling. He speaks of that as a vestige of slavery. He says that one need only look to the legislative record to confirm that the 13th Amendment not only prohibits slavery, but also guarantees freedom from badges of inferiority. And since racial profiling arose from slavery and is a restraint on liberty, it is therefore the type of badge of inferiority that the 13th Amendment was designed to combat. As in the previous article, he is attaching history to our understanding of constitutional interpretation, but not just limited history. He would include slavery in all its gore, in all its violence. He would include its legal authorities. He would include even the way that it taught white people to view Blacks and its overarching dehumanization, all of which we seem to kind of, we don't emphasize that perhaps as much as we ought to when we talk about slavery. What struck me the most about this paper, and there were so many things that really pulled at me, but what struck me the most about this paper may be some of what he says early on in the paper, which in a sense informed, or rather is related to some of the work that I do in the realm of criminal justice and in the realm of federal sentencing. So early in the paper, he says this, and I'm quoting, "Racial profiling damages law enforcement and the criminal justice system as a whole by undermining the public confidence and trust in the police and the criminal law. This is one reason why the current model of analyzing racial profiling must shift and must come to rely upon the 13th Amendment as Professor Carter has proposed." So then what I'm saying is that the why we should all care about this is what struck me the most. So beyond issues of basic humanity and justice, which is something that we should all care about, the fact of the matter is we all don't. Beyond those issues though, I want to offer to you that our entire criminal justice system is in jeopardy. And perhaps an attack on racial profiling that gets to its historical roots through the 13th Amendment may be a way to alleviate some of that pain. We are currently experiencing a moment when the American people are collectively questioning whether any good thing remains to be found in our criminal justice system. We're in a dangerous space, and reforms must be made because the criminal justice system is rendered impotent when people become less convinced of its efficacy. As with all governmental systems, the criminal justice system must be mindful of public perceptions of fairness and justice. This is because a criminal justice system derives practical value by generating societal perceptions of fair enforcement and adjudication. Studies demonstrate that perceptions of criminal law legitimacy give rise to higher levels of cooperation and lower rates of recidivism. Further, people are less likely to comply with the law overall if they perceive it to be unjust, or with the law generally when they perceive the criminal justice system as tolerating injustice, such as racial profiling. People need to feel as though the system utilizes fair processes and produces fair outcomes. So even those who are physically untouched by racial profiling and one of its horrid consequences, police brutality, have in this moment lost their belief in our system. In utilizing the 13th Amendment to combat racial profiling, Professor Carter's proposal attaches the unignorable history of slavery to the problem, thereby offering a viable solution that could be a step in salvaging the entire system. It also offers hope that the constitutional guarantee of freedom for Black Americans can finally become realized. So I am really, again, like I said before, honored to have been a part of this conversation. And I hope that some of what I've said is helpful in sparking discussion today. Thank you.
Thank you so much, Professor Jefferson-Bullock. So we do have a couple of questions in the Q&A, but before we get to those, let me turn it back to Professor Carter to see if he would like to give reactions or response to those comments.
I do, but I'm going to be very brief because I could discuss this with the two of them all day. So I do want to leave enough space for those questions, but there's just one thing it would be helpful to hear both of you reflect on because I think it's relevant to your work for different reasons. So David, you've done a lot of qualitative work, both with police, but also and particularly with communities that are affected by disproportionate and racialized policing. And Professor Jefferson-Bullock, you of course were and are not only a scholar who delves into these areas deeply, but we're also in the trenches of the justice system for a long period of time as a practicing attorney. And so I wonder if in either of your work from the communities with whom you've interacted as scholars and as lawyers, you see any points of resonance of these 13th Amendment themes within your communities. Do people make these connections historically to the treatment of Blacks to modern day treatment today? Is it something that seems to resonate with how communities are experiencing the criminal justice system or civil rights today?
Professor Jefferson-Bullock?
Sure. So I would say this. So for people like me who sit and study these things, the connection is quite clear. I think, though, that we have some convincing to do of the larger community. And I think that is because people like to reject the idea that slavery still has modern day consequences. It is something to convince people that the consequences of slavery exist still today and that slavery still has effects on Black America. It's going to take a mountain of education, much like the article that you presented. So for me, the connection is clear. But I think too, embedded in some of that resistance to the idea that slavery still matters is perhaps a bit of maybe, let's call it an inability or an unwillingness on the part of those in power to say that perhaps somewhere in the history of our country, we actually got it wrong, right? And that we should still be concerned about what we did wrong so many years ago. I think it's that unwillingness to admit that. It's a bit of shame, or perhaps just an unwillingness to accept blame. And so that is why perhaps the connection, which to us in this room is so very obvious, is difficult for people in the real world to accept.
I would agree with that. I especially agree with the last point that you made, Professor Jefferson-Bullock, the unwillingness of leadership to accept anything, that there might be a connection between slavery and the present day. The feeling is, I'll get over it. That was a long time ago. I do feel just a little bit hopeful in measuring the reactions I get from people and audiences when I talk about this. I can remember for the first time showing some slides as part of a talk that included both a slave patrol badge, a badge that a person in a slave patrol actually wore, and then a badge worn by an enslaved person, a sort of a pass that person would wear pinned to the person's clothes. And that was 7 or 8 years ago, maybe 6, 7 years ago. And people were just stunned that these things were in existence. And when I talk about that now, I don't get that sort of flash of, wow, this I never even heard. Now there's a little bit more of, oh yeah, yes, I see that. It isn't quite such shock, I guess. And I like to think that is maybe just a little bit of progress.
Wonderful. Then I'm going to start taking a few of the questions from the Q&A, and I'm going to remind the participants, rather than raise your hand, if you could type your question into the Q&A. So, question from Samuel Franklin. Professor Carter, how, if at all, do you see the remedial motivations or aspects of the 13th Amendment supporting a case for reparations or damages? to former slaves and their descendants?
Yeah, thanks for the question. I'll be brief because I've never had occasion to research it deeply. So this is just intuition, but my intuition is that a similar kind of reasoning could be drawn from the post-Civil War Constitution. That is to say, the argument would be that if you want to eliminate both enslavement as well as the lingering vestiges of it, then we need to grapple with the effects of it, not just upon the criminal justice and civil justice system, but also with regard to issues like the inherited disparities in the accumulation of wealth and income and education and opportunity, all of which have had, in my opinion, a cascading effect, beginning with the system of enslavement and coming down to the present day. I do not know whether scholars or litigants have employed 13th Amendment arguments specifically in reparations cases, but my intuition is that it would have some resonance in that context as well.
Okay, and this question isn't directed to any one of you specifically, so if any of you has an answer to this, feel free to jump in. This question is from Professor John Pushinsky. Has anyone made the badges and incidents of slavery argument against racial profiling in court yet? And if so, how has the argument been received?
I can answer that one. So yes, in a couple of cases where I just happen to know my work was cited, one in Massachusetts that the Harvard Civil Rights Clinic was amicus on, and then another, and I cannot remember the state, but the NAACP Legal Defense Fund was amicus on that, have made explicit racial profiling articles. I can't say I followed the ultimate case history, but I do not believe that those arguments carried the day.
What a shocker. Okay. And a question from Professor Kevin Ashley. How have the courts and academics determined the meaning of badges or incidents of slavery? How should they do so if different from how it has been done?
Yeah, it's a good question. So in an article not under discussion today, I kind of take a step back. This was an article in the UC Davis Law Review to try to suss out what meaning and content should be given to the badges and incidents of slavery if we conclude that it should have continuing legal validity in applying the 13th Amendment. And the answer is complex. I'll answer it as briefly as possible in two aspects. As to what the courts have done, the answer is almost nothing. So there was a Supreme Court case called Jones versus Alfred Mayer that I mentioned earlier, which applied the badges and incidents of slavery interpretation of the 13th Amendment to uphold federal housing segregation law, right? And held that widespread racial segregation is a badge or incident of slavery. Aside from that one case, the Supreme Court has not really explored the meaning and content in any depth, and the lower courts have generally rejected badges and incidents of slavery arguments. The reasoning being this: in their view, I do not agree with this, in their view, there is a badges and incidents of slavery power in the 13th Amendment, but that power is granted to Congress by virtue of Section 2 of the 13th Amendment, which says Congress shall have the power to enforce this article by appropriate legislation. So judges should interpret the 13th Amendment's first section as only reaching literal enslavement and involuntary servitude, these courts have said. Whereas Congress, if it chooses to rationally define a condition as a badge or incident of slavery, may do so, okay? And in fact, as Professor Jefferson-Bullock said, it's important to remain grounded, but to have a little bit of hope. In fact, Congress has done so fairly recently in the James L. Byrd and Matthew Shepard Hate Crimes Expansion Act. They relied specifically on their 13th Amendment power to define violence against broader groups of people as a badge or incident of slavery. And so courts have not been terribly receptive to the claims, but they have also been pretty deferential thus far to Congress's use of that power.
And I know we are now at 1:31, but we are getting several really good questions in the Q&A. I thought I'd go just another couple minutes if it's okay with our panelists, but I'm not going to go longer than 1:35. I know a number of us teach it too. But the Matthew Shepard example is a great segue to this question from Ann Bloomberg. If I understand correctly, 13th Amendment is meant to address the badges and incidents of slavery, including the system of racial hierarchy, aka white supremacy. Under this understanding, do you believe the 13th Amendment could be expanded to other groups that face unjust treatment as a result of white supremacy, for example, in the immigration context, or do you think that would be stretching it too far?
So again, I'll try to be as brief as possible, but this is also a very important and complex question. My article in the UC Davis Law Review really delves into this. Here's the contradiction. On the one hand, we know from the historical evidence that the framers of the 13th Amendment, as well as the ratifying public, understood that the 13th Amendment would do more than end chattel slavery, and would in some manner, whether judicial or legislative, address the badges and incidents of slavery. We know that. And we know that the most immediate subjects of those badges and incidents, both historically and today, would be African Americans. On the other hand, when you read the framing debates, the framers of the 13th Amendment absolutely agreed that the badges and incidents of slavery fell most heavily on the slaves and their descendants. But they believed that slavery and the racial hierarchy and the system of inflicting violence with impunity and the history of night riders and terrorist mobs had distorted the country as a whole. They intended to root out those vestiges wherever they would be found, right? Yet it's a bridge too far to say that every form of inequality is a badge or incident of slavery. It's not. And so what I propose in that article is think of a matrix whereby one axis is the connection that the claimant has to the institution of slavery. So closest to that would be African Americans and their descendants, but we may see other subordinated groups that suffer similar harms arising out of the legacy of slavery. And on the other axis, I'll do it that way, the other axis would be what's the nature of the injury being inflicted? How close is it to the core of the structures that slavery created? So is it forced labor? Is it a human being as property? Is it the infliction of terrorist violence? Is it the denial of civil rights based on status? And so you can be at various points on these axes where the badges and incidents of slavery argument has greater or lesser force. So the short answer is I do believe it could be extended to other groups. But in my work, I try to be careful to keep the focus on the people who were most affected by the system of slavery as well.
And I'm going to make this the very last question, and it is a profound one for Professor Carter, and this is from Vincent Napoleon. Does the 13th Amendment reserve the possibility of the existence of slavery in the modern day, particularly as it relates to the modern day criminal and penal justice system? If so, is slavery truly abolished?
Yeah, so this is the subject of much contemporary debate about the meaning of the punishment clause of the 13th Amendment. So the 13th Amendment says that neither slavery nor involuntary servitude, comma, except as punishment for a crime whereof the party has been duly convicted, comma, shall exist in the United States or in any place subject to their jurisdiction. Critics of the punishment clause contend that the inclusion of that clause allows for the replication of slavery, particularly of incarcerated persons and persons post-incarceration. I understand that, and there is a pretty active campaign called Amend the 13th that is proposing a constitutional amendment that would strike the punishment clause from the 13th Amendment. I do understand that it has created an opportunity for exploitation of incarcerated persons. I, along with some other scholars, though, don't believe that that was the intent of the punishment clause. And there's not enough time to talk about it now. Suffice it to say that that view, that one's status as an incarcerated person deprives them of the protection of the 13th Amendment, is a distortion of the 13th Amendment that was first articulated and used by pro-slavery Democrats after the Civil War in order to justify things like convict leasing and continued de facto enslavement. It is a perversion. That said, it is one that has been grounded now in a century and a half of constitutional history. And so I think the Amend the 13th movement has a reasonable argument that we're not going to undo it by clever, novel legal approaches. We need to change the language.
I think we're going to need to leave it there then. I want to thank very much Professor Carter for sharing your scholarship with us and for all of your contributions in this field. And I want to thank our wonderful commentators, Professor Harris and Professor Jefferson-Bullock, and thank our Dean for all of the support for this great scholarship at Pitt Law. And thank you to all of our participants. I think it's been a very memorable Constitution Day. Thank you, and have a wonderful day.
Thank you all so much.